This is the talk for the paper Legal Taxonomies of Machine Bias, Revisiting Direct Discrimination by myself, Reuben, and my colleagues Jeremias, Adams-Prassl and Aislinn, Kelly-Lyth. There's a default assumption in machine learning fairness literature that ML fairness metrics map onto certain categories in discrimination law. So in the US, there's a distinction between disparate treatment and disparate impact. Disparate treatment is where a person is treated differently because of their protected characteristic. Disparate impact is where there's an application of a facially neutral policy which causes a disparate impact on the basis of a protected characteristic. Similarly, in the EU and UK discrimination law, there's direct discrimination, which is where one person is treated less favourably than another has been, or would be treated in a comparable situation on grounds of a protected characteristic, versus indirect discrimination, the application of an apparently neutral provision, criterion or practice which would put persons with a protected characteristic at a particular disadvantage compared with other persons. Machine learning fairness literature has primarily focused on disparate impact, and the variety of different fairness metrics that have been proposed generally are thought to correspond to disparate impact. It's similar in the EU context, where group fairness measures are assumed to be capturing the same thing as indirect discrimination. So both disparate treatment and its EU counterpart, direct discrimination, are largely ignored in fair machine learning research. So why is that? One reason is that disparate treatment and direct discrimination are typically understood in terms of fairness through unawareness. This simply consists of not using protected characteristics as inputs to the decision. So if we take this understanding of disparate treatment and direct discrimination, it seems to raise no interesting technical questions because it's just a case of removing certain features from your model, whereas disparate impact and indirect discrimination are seen as tough cases where we need to define new kinds of algorithmic fairness measures. We also argue that the preference for measures that are defined in terms of impacts on groups reflects a broader philosophical orientation of machine learning, according to which we want to evaluate models in a model-agnostic way, so we can use the same evaluation metric to evaluate a deep learning model versus a simple decision tree. Now, we argue that these assumptions may be correct for US discrimination law, but despite surface similarities, EU discrimination law differs in some important ways. Notably, the scope of direct discrimination is broader than that of disparate treatment. This means that there are many algorithmic systems that will be directly discriminatory under EU law, even though they might only be disparate impact under US law. Now, there's very little scope for the decision maker to justify direct discrimination. For the full legal argument, see our previous paper in the Modern Law Review entitled Directly Discriminatory Algorithms. So what are some of those differences between EU and UK discrimination law versus the US equivalents? So one is that direct discrimination, unlike disparate treatment, doesn't need to prove intention on the part of the decision maker. Furthermore, direct discrimination explicitly includes cases of implicit bias where the decision maker is, unbeknownst to themselves, discriminating on the basis of protected characteristic. This is contested in the context of disparate treatment. Now, UK law has defined two different types of direct discrimination: inherent discrimination and subjective discrimination. In the context of racial discrimination, these were distinguished in terms of a decision or action taken on a ground which was, however worthy or benign the motive, inherently racial, or because it was taken or undertaken for a reason which was subjectively racial. Inherent direct discrimination is where there's an exact correspondence between those who suffer the disadvantage and the protected characteristic. An example of this comes from James versus Eastleigh Borough Council, where a local council in the UK offered free swimming pool access to individuals who were eligible to receive the state pension. Now, the pensionable age at the time was 60 for women, but 65 for men. And the court in this case found that the reason for differential treatment was sex, even though the swimming pool didn't explicitly mention sex in their criteria. We give some examples of criterions and features that we think would be inherently discriminatory in the paper. So one example would be marital status in a jurisdiction where marital status is unavailable to people of certain sexual orientations. Another example would be the use of the fact that a candidate went to a women's college in a hiring algorithm. And we also present the example of a proxy which is based on multiple different features. So imagine there's a school that was previously single sex and then it started admitting girls. And you had a decision rule that included only graduates of that school, which is not in itself inherently discriminatory. But you coupled that with another decision rule that said we want people who were born before 1990. Now, those two decision rules together might actually exclude women from succeeding with the hiring algorithm. And so there's no difference between using a single feature or using multiple different features when it comes to inherent discrimination. Subjective discrimination is where the discriminator may unconsciously be making his selections on the basis of a protected characteristic. He might not realise that that's what he's doing, but that is in fact what he's doing. And in this case, the protected characteristic only has to have been a cause, not the cause of the outcome. So you can imagine situations where algorithms learn to replicate implicit biases of humans who've trained them, who've created the labels that they're trained on. The Amazon recruitment algorithm, again, would be an example here, where the algorithm learned to prefer traditionally masculine traits because those were the ones that were favoured by the humans who created the training data. So we argue that these different types of direct discrimination mean we need new ways to measure direct discrimination in algorithms. Anti-classification is not sufficient to identify the varieties of direct discrimination, and we may need new measures and methods that are appropriate depending on the type of direct discrimination we're interested in. We don't discuss subjective discrimination much in this paper because it's not easily algorithmically tractable. It involves social processes that are not necessarily observable in the data. However, we do talk at length about detecting inherent discrimination. And we do that by imagining an ML model that's used to allocate free swimming pool access. This is an algorithmic equivalent of the case of James versus Eastleigh Borough Council I mentioned earlier. So if you're a data scientist designing this model, you might ask, are any of the features that I'm using indissociable from protected characteristics? So you might run a bunch of correlation tests, and you might find that a feature that you're using, the fact that an individual was a patient at a particular health clinic, that might be perfectly correlated with pregnancy status because it turns out that health clinic is for pregnant people. Now this would be a case, we argue, of inherent discrimination. Now imagine you run a correlation test on the received state pension variable. You might find that this is only weakly correlated with sex, and therefore you might conclude that it's not direct discrimination. At best, it's indirect discrimination. But what if we look at a subset of age, as they did in James? Here we would find that while there is not a perfect correlation between pension and sex, when we look at a subset of age, between 60 and 65, then we find that sex does perfectly predict pension. And in this case, we'd argue, again, this is a case of inherent discrimination. So some questions are raised for how we detect inherent discrimination. One is, how do we systematically compare every feature against every protected characteristic, including these subranges? Another is, how do we address different model types, e.g. decision trees versus neural nets? Another is, how strong does the correlation need to be? The UK courts have held that the correlation must be perfect, but in the Court of Justice of the European Union, they've held that it can be less than perfect. So what are the important implications for fair machine learning? One is that there's a broader scope to challenge machine learning systems in the law. So wherever a model uses a feature which is indissociable from a protected characteristic, it is directly discriminating and therefore cannot be justified in the law. Also, this doesn't need to be a single variable. It could be a combination of different variables and subranges within them. And we may not need to have a perfect correlation, depending on whether we're relying on the UK jurisprudence or the CJEU jurisprudence. Subjective and inherent discrimination are just two types of direct discrimination. They're not necessarily exhaustive. So there might be other cases where we could argue that algorithms are directly discriminating, and we suggest that race and gender biased facial recognition technology might be one example for that. and it's open for courts to define new forms of direct discrimination which are better suited to addressing algorithmic harms. Thank you.